Welcome to Tax Masterclass. I am Advocate Anthony Williams, and you're watching Tax Masterclass. Normally, videos on Tax Dosti YouTube channel are in Urdu, but since foreign investors and people who understand, or rather who don't understand Urdu, we have decided to make this video in English, and this is a comprehensive video on how to incorporate your business in Pakistan. And by incorporation means making it a private limited or a public limited company. And the government authority that deals with incorporation of companies is the Security Exchange Commission of Pakistan, SECP. This is secp.gov.pk, and all the compliance a company has to make is made through e-services, and this is a portal, self-help portal, where nationals can register as well as foreigners can also register. And once you are registered, you log in, and the different forms that have to be filled are given here, starting from the incorporation of a company. And the website is very helpful. It gives you all the detail of how to incorporate a company. First, how you have to register with the memorandum and article of associations, then running of the company, the annual compliance accounts, changes in company details, and even if you have to wind up your company, or if your company was not successful in starting commercial activities, you can do company easy exit rules. So, we'll be talking about the company law, which regulates the procedures of incorporation, of running a company, of changing a director. So, it's a tall order. I'll start, but a few things before that. First of all, if you want to start a simple trading business, an import export business in Pakistan, and you want to form a company, you have to do it through the Security Exchange Commission of Pakistan. And even if you want to start a company, like for example, a non-financial, non-banking financial institution, or an insurance company, or a clearing house, or any of these specialized companies, you first have to register it with the Security Exchange Commission of Pakistan. So, if I were to divide these two types of companies, one is for the physical economy. If you want to open a manufacturing unit, or import export business, or a beauty parlor, or for example, or a school, you have to incorporate a company, including a charity company, with the SECP. And what will be the law and rules, we'll see in Companies Act 2017. But if you want to open up a financial market company, a company which deals with financials, insurance, venture capital, real estate, investment management services, or a charity company, you have to open it under section 42, a charity company. And these other companies also, you have to register it with the SECP. And in these companies, the memorandum article will allow you to open and maintain a stock exchange, a commodity exchange, etc. Other than that, there are other enforcement and Islamic financing options that if you get into, you have to register it with the Security and Exchange Commissions. And even the SECP is encouraging startups in Pakistan, encouraging startups in Pakistan to register as companies, though they are not required to start as a company. They can start as a sole proprietor, as a partnership, a regular partnership business, but it's encouraging startups to incorporate as a company and to start their life on a proper footing, so that corporate governance and compliance with different legal matters and tax matters is done in a way which is beneficial for them. And the company law that is prevalent in Pakistan is Company Act 2017. So we'll be discussing this act, the Company Act 2017. It was replaced by the Companies Ordinance 1984, and it's a tall order. There are many articles, sections in this, but we'll try to discuss what's most important, so that you have an idea that once you form and incorporate a company in Pakistan, what are your rights and duties, that of the directors as well as of the shareholders. And there are some special provisions now which you have to follow to disclose your shareholding in Pakistan and outside of Pakistan. So let's start, Ji. The first thing is that why should we open a company? Why should we incorporate our business as a company according to Company Act 2017? So the answer is simple. If your business is in one city or in a few cities, or if you run a national business, or if you are an international business coming into Pakistan, there are few very straightforward questions that incorporating a company answers. First of all, if you incorporate a company, the flat tax rate that you have to pay is 29%, and it's reducing every year. So in the near future, it will be 25%. If you start your business as an individual or as a partnership business, then your tax rate, if you earn profits of more than 10 million in a year, you will have to pay profits of 30 to 35%. Whereas incorporating a business, you will have to pay taxes on your profit from 20 to 25%. So incorporation of company business, incorporating your business as a company, the first benefit is that if your annual profits are more than 10 million in a year, then you have to pay, in order to fix your tax rate, you can incorporate a company and you will be paying between 20 to 25% on your profits. Whereas if you are an individual as a sole proprietor business or a regular partnership business, you will be paying somewhere between 30 to 35%. So if you are earning a lot of profit, be it a service company or a manufacturing company or a trading company, the tax rate is the first thing. And the second thing is that if you own a lot of personal assets, or if you want to protect your international business from your Pakistani business, then you should incorporate as a company, so that if any losses occur, they are limited to the paid up capital of your company in Pakistan. So these are the two reasons that you should use to incorporate a company. Now let's see that these are the different definitions, and the Company Act 2017 has been amended once, and a few sections have been added. There was an amendment in the year 2020 which included the definition of startups and a lot of facilities for startups. The company law was amended so that startups can issue partly paid up shares, but that was not ratified by the National Assembly, by the Parliament. So those incorporations have not been incorporated, though they were very wonderful incorporation for startups and for any business that is technology based or financial business. But the regular the regular company law gives a business a clear idea of what kind of rules, regulations they have to follow. First of all, they have to have bylaws which are called articles of association. And another important thing is, whenever a foreign company, or if you have an existing business and you incorporate a fresh company, you have to be aware of who is your associated company, and that can have a bearing on your company. Authorized capital means the total number of shares that your company can issue. Then beneficial owner of a shareholder or officer of a company. This is new term, meaning that maybe the existing shareholders may be proxy shareholders, and they may not be the ultimate beneficial owners of this shareholding. This definition has been introduced to identify companies which launder money, or that those that cater for terror financing. So these are the few changes from the previous law which are new, and they have been defined that who is a beneficial owner or shareholder. Board means the board of directors. Body corporate means a company that is formed under this law, or any other body, any other company that has been incorporated outside Pakistan is also a body corporate. And some other thing, some other definitions. Books of accounts means details of sales, purchases, assets, and as a company you have to have your books in orders, and you also have to have it audited by a local chartered accountant or cost and management accountants. Therefore, chartered accountants have been defined. The term chief executive has been defined, and it means an individual who controls and directs the board entrusted with the activities management of the company, and includes a director or any other person occupying by whatever name and whatever contract. So a chief executive may not be a director, or he may be a director. The chief financial officer has been defined, so that the responsibility has been fixed, so that any financial fraud, or the first responsibility falls on the CFO, chief financial officer. Company law includes the previous Act 1930, 84, including 2016, and this one also. Then the company can be limited by guarantee, limited by shares. Company secretary has been also defined, so the responsibility of all the secretarial work and the compliance of this company law is primarily of the company secretary. The cost and management accountant can also audit your accounts if your paid up capital is less than 10 million. Then other definitions like the director, document, e-services. You just saw the e-services on the SECP website, where you have to make where the company secretary has to make all the compliances with different forms. Employee stocks option has been introduced, so that employees can be given shares. Expert, financial institution, financial period, financial statements, obviously. Then financial year. Foreign company means a company incorporated, which is a place of business or liaison office, in whether by itself or through an physically. To differentiate it with foreign companies that are incorporated outside and then register with the SECP and then become local companies, these are foreign companies which do not just have their liaison offices. Then government, holding company, listed shares. Memorandum, that is the constitution that states the basic objective, the basic activity, the primary objective of, and it's important that your memorandum state the business according to the name of the company. Then net worth, notification, officer, private company, promoters, public interest companies. So companies have been defined. Public interest companies are companies where the owner is government or the activities are such which provide directly facilities to the public. Redeemable capital, register, registrar, securities, share there. You can also incorporate a sole proprietor business directly into a single member company, which means that sole proprietor will become the owner, chief executive, and sole shareholder of the company, and his private assets will be protected, whereas his tax rate will also be fixed between 20 to 25%. Special resolution subsidiary, and since the the amendments proposed in the year 2020 were not approved, which included defining a startup and other things which would enable startup businesses to easily incorporate and then hold their shares and then issue them later, or issue them for in return for goods and services. So those amendments have not been made. The company law is uh, is providing regular businesses like manufacturing business, trading business, or financial institutions the way to manage their business. Acha ji. This says that some sections will obviously be of no use for you till you incorporate your company. So these are for advocates like me. The jurisdiction of the court, where will be the uh, where will be the jurisdiction if there is dispute between shareholder, and the simple answer is that the registered office in Pakistan, for example, if it's in the Punjab province, Lahore city, or if it's in the capital city, Islamabad, it will determine the jurisdiction of the court, and the winding up proceedings will fall in the original jurisdiction of the High Court. As far as the functions of the Security Exchange Commission of Pakistan is, the commission is the highest body and is chaired by the chairman, and then it can make reference to the federal government. Now let's start with part 4 and see how do you incorporate your business according to law. First of all, if as a partnership business you become a partnership business of more than 20 persons, then it's compulsory for you to incorporate a business. Normally people think that you can start a company if you are one person or two persons. That's correct, but the main reason why company law became compulsory was that partnership businesses were growing to become very large. People were partnership businesses were becoming with 20 and more partners, and it was becoming very difficult since partnership business is controlled by the partnership deed document which outlines all the rules regulations. So you needed a standard law which regulated businesses with large owners, with large ownership. So if you have a partnership business and you become more than 20 persons, then you have to incorporate that association, that partnership business as a company. Now, the first thing is that you have to keep a business name of your company, and while you are filling the incorporation form, you have to give three names or three suggestions to the SECP while incorporating your business, and that name should match your main business objective. There are a few names that you cannot keep. First is identical or similar name of another company, so that if another company is successful, you just can't keep that name and trick people into thinking that that is an associated company or this is the same company. So just like trademark and patent, you can't have a similar name. It can't be inappropriate, undesirable, disruptive, and exploitive. which means that when you file on e-service your incorporation form in which you give three names, the SECP has the power on the basis of uh, these criteria to reject your name, and obviously you can't keep it on the name of any patronage or foreign head of state and some other prohibitions also. If it's restricted, then you can appeal to the commission and the commission's decision will be final. Rectification of a name of a company means that if you have set up a company and now you want to change the name because of any reason or a change in business objective or line of business, then you have the option. Because remember, if something is not provided in company law, then that facility or that prohibition will not be applicable to you. So you can change this name with the approval of the registrar. Registrar is a person who is the head in your city, and there are different registrars: senior registrar, joint registrar, deputy registrars, according to their seniority. And the registrar is responsible for the office in your city. For example, I'm in Lahore, so the registrar of companies in Lahore is responsible for all of implementation of company law, and the commission sits in Islamabad and the chairman sits in Islamabad, and the registrar is the functional head, and the commission and the chairman are the legal heads of SECP. So you have to inform them in 30 days, and all the procedure is laid out here. Change of name by a company, this gives you the option of change, and this is a rectification. If, for example, is registered by name in contravention of provision of section 10. So if this section 10 is violated, but somehow a mistake is made on part of the SCCP staff, the law gives them the right to rectify the name. And if you want to change your name because you have changed your business or your line of business, you can change it under section 12. Now the important thing is that for all these sections there are separate forms on your e-service module, as we saw. And once you log in into your e-service, you can see change of name there, and then you have to fill the details and pay a amount of fee, and then the registrar will give you approval. Now once obviously you register, of there is a name change, obviously there are things that have to be changed, like the memorandum, the certificate of incorporation. So all these documents have to be changed, and there is a time limit which normally the SCCP follows, and in a very professional way they give you all the documents, amended documents, modified documents. These are different types of uh, companies. Three or more persons can open a public company. Two or more persons can open a private company. One person can form a single member company, and then a few more details. Then the company can be limited by shares, which means the capital, the money you invest, you get in return shares from the company. If you open a company limited by guarantee, that means that when the company needs the amount of money that you guarantee, then you'll have to pay. Or you can also start a company which has unlimited liability, which is just like a regular partnership business. Once you start a company, you cannot go below that number. For a public company, you can't go below 3. In case of private company, 2 members. And members includes the shareholders, but in terms of guarantee, members is a person who has guaranteed an amount. In terms of shareholder company, member is a person to whom shares have been uh, issued. So now we'll go through some general provisions First of all, when you are starting a company, along with the name, you have to give the main line of business, memorandum, the constitution of the business, and bylaws, articles of the business, and they have to be declared on a specified way. When you are incorporating a company, so the SECP has made it very simple. If you are starting a standard business, that could be an e-commerce business, or that could be a trading company, or that could be a import-export business or a manufacturing business, the memorandum of association are given in a standard way, and if you select one of them, you can all the standard wording of that document will be given, and on the SECP website you can also go through the list of this memorandum of association. These are the memorandum of association of different companies. You can see parlor, e-commerce, courier service. So if you were starting a company, a fitness center club, you could simply select this while you are incorporating a company, and all the legal wording will be automatically populated in the form, so you don't have to design and spend money on designing the memorandum of association. So this one facility has greatly achieved ease of doing business, and you just have to inform the SECP while incorporating a company what kind of business you are doing. If you are doing any business for whom the memorandum is already made, it will already be auto populated in your form, and you don't have to. If you are doing a specialized business, then you will have to make a, with the help of advocates and lawyers, a memorandum which will state the special nature of your business. Uh, the articles are bylaws, and mostly if you don't want to alter these bylaws, then whatever we will see in this video in the coming minutes, you'll have an idea how to manage and what the company law says about how do you manage your company, how do you elect your directors, who are shareholders, how can they call meetings, how frequently meetings will be called, who will appoint the auditors, etc. So all of these things are given in bylaws, and one reason the partnership business company is preferred over partnership business, because almost all eventualities are given in company law, and company law has been developed for the past 300 years. So most of the eventualities are covered in the bylaws, which give you legal cover. So once you decide if you want to go with a standard memorandum and a standard article of association, this section says that you have to register them with all the details, and once you register them, that means that you have incorporated a company, and the share money, the paid up capital, which we call the subscriber money, has to be within 30 days of incorporation deposited in a bank, so that the company has the paid up capital to start its business. This also tells that this company is not a shell company or a fictitious company. This company has been made to do real business. So within 30 days of the incorporation of the company, after registering memorandum and articles, cash has to be paid in the bank by the subscribers to the memorandum, whom we call promoters, and if they are not, then the company loses its status of a company, and a certificate has to be issued by a practicing chartered accountant or a cost management company within 45 days of incorporation that this money has been. So the company and its director have to deposit the money within 30 days of incorporation, and the auditor certificate has to be given within 45 days of incorporation, and this auditor certificate is then uploaded on the e-services SECP website, where the auditor certificate states that this money has been received, and then the registration is complete. Now commencement of business can be started. If you start a public company, it has to start a it has to get a certificate of commencement of business from the registrar, and the minimum subscription requirement has to be fulfilled, though now this minimum subscription requirement is also compulsory for private limited and single member company. And then these are the penalties for non-compliances. One very important thing which will also affect the tax status of your company is the registered office of the company. When you are incorporating a company, you have to give a physical address of the company, either as a correspondent address, which will help you for the first 60 days, and then you have to give a registered address, or you can outright give a registered address during incorporation certificate online on e-services SECP, that this will be my registered address. The tax authorities will also use that as your registered address, and the income tax authority FBR will give you a national tax number based on your city and province, which will be applicable for all of the country, and your provincial service tax company, service tax authority will give you tax number according to the province in which you are registered. And Pakistan has 4 provinces and 1 capital city. So Islamabad is a Islamabad Capital Territory ICT, and then there is province of Punjab, KP, Balochistan, and Sindh. So you have to decide out of these 5, you have to register your company, and there are some tax and service tax, income tax, sales tax benefits in registering in some that you can consult with your consultants or with us, Tax Dosti team. Our numbers, WhatsApp numbers are given below in the video. So the registered office has to be in a city and a province. This is very important, and especially if you are doing manufacturing and if you want to get your sales tax and provincial sales tax registration, so you have to think before registering in which city and province your registered office should be. Once you during registration you give this, then publication of name. This is a requirement that wherever you go, you'll have to display your company name, and you'll have to have your company seal, a stamp, and these are the penalties for not doing that. Okay? And you also have to publication of authorized as well as paid up capital. So you have to make a complete details on name and paid up capital, so that people dealing with you know what is your paid up capital, what is your business name, what is your registered address. Now the most important thing in your memorandum, your constitution, memorandum of association, will be the business objectives and your principal line of business. And this section gives you clear guidelines that you should not undertake any unlawful activity. You should only carry on lawful businesses activities, and this, what is lawful and unlawful, your attorney, your advocate will tell you. Some businesses in Pakistan are not lawful. Secondly, your principal line of business and the name of your business should be in line, and your memorandum article should show this. Then these are special provisions for memorandum of a company limited by shares. How will be the name represented, limited, private limited, or SMC, single member private limited, and what will be the liability of members, principal line of business, what province. So this is an outline or format of the memorandum of a share company. This is of a guaranteed company guaranteed by shares, and this is a memorandum of unlimited company. So these are the formats which, while you be incorporating, you will have these facts will be shown there in detail according to your facts. Now, even if you don't mention, your company will have borrowing powers, and you'll have this requirement now has been outdated because everything will be digital, even your incorporation certificate and all the documents very soon in the future you'll get in a digital form. So maybe this is superfluous requirement right now. Then you can alter if you're changing provinces, and these are different provinces including Islamabad, or if you're having a change of line of business, you can alter your memorandum, that too on SECP services. And those alterations have to be confirmed by the commission, and then discretion. Articles of association, the bylaws are given here in the law in table A in the first schedule, and every aspect starting from election of directors, incorporation, paid up capital, accounts, winding up, borrowing power, all of them are mentioned there. So if you want to change them, then you will have to make a special article of association. Otherwise, while incorporating your company online in Pakistan on SECP portal, you just have to mention that I'll be following table A, first schedule, articles of association, and then your article of association will look exactly what is given here in the first schedule, and obviously other information about this. This then again is for physical copies. It clearly states that for online copies it doesn't have to be signed, though date has to be put there. You can alter your articles. There is a complete mechanism on how the articles will be altered, or the memorandum altered, for which you'll need permission of the shareholders. The directors will call the meeting, the shareholders will get the permission, they'll explain why they are changing. So these are all. Then copies and things like that, you can get hard copies from SECP by applying online on your e-services portal. And then there is a separate type of company, a charity company or a not for profit company. You have to register it under section 42, and uh, uh, this requirements have been growing for uh, different for charity companies, because a lot of money laundering and terror financing activities have been done by illegal companies who are registered under section 42 of Company Act 2017, or Companies Ordinance 1984. So the requirements to register as a non-profit company have become stringent. So if you intend to do this, there's a long list of rules along with all of these legal sections. Moving forward, you can also convert a company into another company. These are the sections that we deal with different types of company. The most prevalent is company limited by shares. Now certificates, then obviously once you convert a company, all the share certificates have to be changed. Now how the documents will be authenticated and services. So service of documents on a company will be according to the registered office. It can be in electronic means as well as physical means. So these are the way documents are served on a company. So registered office is very important. And then how will the notice be served to the members of the company? So here, according to the registered address of the member, and if no registered addresses the company for giving notice to him as acknowledgement by post or courier or electronic means. So these are the ways the company will be incorporated, the registered office will be decided. Now, regarding shares, if you are a public company, you will have to, and if you are uh, inviting the public to invest in your company, you have to issue a prospectus, and you can have different classes and kinds of share capital. A company having share capital shall issue only fully paid up shares, which may be different kind of shares and class. So the shares have to be fully paid up, which means that once you uh, print the shares, you have to issue to the members. You can't print and keep those shares. They have to be fully paid up. Neither can they be partially paid up, which means that you have to, if it's a 10 rupee share, you have to get 10 rupees from the shareholders uh, when you issue the share to him. Though you can have different kinds of and classes, A class, B class, with different paid up values. One share can be for 5 rupees, one can be for 10, the other can be for 100 rupees, and then different rights and privileges can be waived. Now, the variation of the rights of shareholder of any class shall be affected only a manner laid down in 38. As we are seeing that you can only change when a majority of shareholders give you the right to change the voting rights or other rights of the shares. Now, the shares will be numbered, and the certificate they'll be in the form of certificate, number of shares. You can also issue debentures, that is bonds, debt you can issue, and these are different sections relating to how you can pay the members or the debt holders. There has been a change in section 66, and that change relates to, let's see what is the change, 60A, section 60A, and now you cannot issue bearer shares or bearer share warrants like you used to do. So let's see if we could go back to the company law and section 60. Section 60 said that every share in a company having share capital be distinguished, provided that nothing in section apply to a share held by a person whose name is entered as holder of beneficial interest in such share in the records of central depository. Now, beneficial ownership has been, you have to disclose who is a beneficial owner, and section 60A says that now companies cannot issue bearer shares or warrants. Every share issued has to be in the name of a real person or a company. So this is one amendment that happened in this year, tax year 2021, and another we'll see when we come to section 123. Allotment of share is the application of shares in debenture. A company in pursuance of shall issue shares less than the nominal amount as the allotment of shares. This is the allotment of shares when you issue prospectives. Those that have successfully bid for that shares get those shares, and the other people who were unsuccessful, they are repaid their amount. Then allotment of shares and securities to be, this is related to listed companies whose shares are on the, and this is the annual return that you have to file. Every company, private limited company, public limited listed company, single member company, has to file an annual return showing how many shares were issued during the year, to whom they were issued, and these are the requirements, different requirements that have to be fulfilled. and normally in October this annual return, which we call Form A, has to be filed every year by the company, showing how much shares have been issued, who were the company directors, what were the changes between company directors. Then this is certificate of shares and relating to. This section has also been now enforced by SECP that every company, be it a private limited company, a public limited company, a listed company, or a limited liability partnership, it has to now demutilate its physical share and convert it into a digital book entry with the Central Depository Company of Pakistan, which is a company entrusted with the digital keeping of all the shares of different companies. So the private companies also have to issue now digital shares. The transfer of shares, this section deals with transfer of shares, and as you know that the transfer of shares has to be given permission in case of private limited company. In public limited and listed company, you can freely transfer your shares, and there is restriction on transfer of shares for a private limited company. So after incorporating your shares, we are discussing that how do you issue shares, transfer shares, and now make them into digital. And in cases of a deceased member or successor in interest, these are guidelines which you won't find it in a public, in a partnership business or a sole proprietor. So incorporating your company according to Company Act 2017 gives you a lot of legal cover to all the eventualities that happen regarding different aspects of management of the company. You can also issue companies shares on a premium, and that premium will be kept in a separate account. You can also issue shares at a discount with these restrictions, and you can further issue shares, which means that if your authorized capital is 1 million and if your paid up capital is only 400,000, then out of 600,000 you can issue further capital. You can take it up to 1 million, and that further issuance of shares will be first offered to the existing shareholders. Then if they decline, it is issued to new shareholders. The amendments regarding startups that was proposed in the year 2020 were dealt with these matters, where they gave the option to directly issue further share to venture capital and third parties. But since that has not been incorporated, so that those changes are still not part of the Company Act. The Company Act is going on the same lines as for regular companies, not for startup companies. Achha, these are the different sections. Now, no company can invite public to deposit money with them. There is a clear prohibition except banking companies. And banking companies, though they are companies, but they are regulated under the Banking Companies Ordinance 1962. And you are watching Company Act 2017, which regulates most of the companies. But if they are specialized companies, banking companies, non-banking, then there are other special laws in conjunction or in line with this company law. So they also have to follow company law while incorporating and setting up, and then they also have to follow those special laws if you are setting up a special company. And you may also have to get permission from State Bank if you are incorporating a banking company or a non-banking financial institution. You can also alter your share capital. You can decrease your authorized capital, but then it will be extinguished. You can also, there is a prohibition on the purchase of company or giving loan to purchase its own shares. So the company cannot purchase, no company having a share capital other than a listed company shall have the power to buy its own share. So treasury shares are only possible if you are a listed company. You can buy back your shares, but then you may have to, if you read this section in detail, you have to cancel those shares if you are a listed company. If you are a private company or a public limited company, you can't buy back your shares. Once they have been issued, the company cannot buy back those shares, though those shares can be traded in secondary markets or maybe on the listed stock exchange, but the company itself cannot buy back the company subsidiary company not to hold shares in its holding company. So all these are prohibitions that the company cannot subsidiary company cannot hold the shares of its holding companies. So all these prohibitions are intact. They have not been modified. Today is 24th of May 2021. So as of today, all of these restrictions apply. Power of company to purchase its own shares. Um, on memorandum, listed company may subject to provision of this section. So now for purchase of its own shares by a listed company, these are the rules, and you have to follow this section as well as the regulations rules given uh, uh, for buyback of shares. Now reduction of share capital, the court can of a company that is limited by share, a court can reduce its share capital, which means paid up share capital, and pay off the shareholders, and then obviously objection of creditors, settlement, and all of this the high court will deal, and registration. And there can be reasons why a company going in consecutive losses can reduce its paid up capital so that it can restructure, and then with fresh capital it can move on with its business. So all of these things are given here. Unlimited liability of directors. In a limited company, the liability of directors or any of may, if so provided by the memorandum, be unlimited. So a director may be bound the decisions that he or she is making if the memorandum, normally the memorandum specifies that does not specify this, but if the memorandum specifies this, then a director's liability can be unlimited, and his personal assets will also be available to extinguish the company debts. Special resolution has to be passed. Now, if a company takes on loan and mortgages or pledges its fixed assets or its circulating capital, then these are the rules that all those mortgages charges have to be registered with the registrar, because a public company file can be inspected by any person. He doesn't have to be a shareholder, a director, any person who is interested in seeing the shareholding, the mortgage list, and other details can inspect the file of a company, and all of these details, including memorandum, article, and promoters and shareholders list, will be in that public file. So, to protect the interest of public as well as shareholders, directors, and other stakeholders, if the company decides, that is, the directors decide to mortgage, give pledge any property, that registration has to be registered with the registrar so the other people know, and obviously the shareholders will be told in the annual general meeting. And then these are the different sections which deal with how will those uh, documents be registered, who will get the copy, if there is some rectification change, who will make it, what is the power, and once the mortgage is paid off, how will the company remove it from its name. And if the company goes bankrupt or is unable, and the creditors come to take charge of the company, then these sections will come into play of receiver and manager, and then accounts will be drawn, and then who can be a receiver, appointer, and then application will be made to the court so that the creditors are paid, and the company is wound up, or the debts are paid and the company is restructured. Now we come to the bylaws, or how to manage a company according to Company Act 2017. You are watching Tax Masterclass. I thank you for taking out the time to understand Companies Act 2017. If you are in a business and you are running a company, or if you want to create your company, be it a startup, technology company, or a regular business company, manufacturing, trading, you should be aware on how the Company Act will protect your company name, your goodwill, you as a shareholder, you as a director, etc. So now we'll be discussing in the next 150 sections, we'll be discussing, or I'll be giving you an overview of the important aspects of managing a company from the point of view of shareholders and directors. And then when we come up to section 280 onwards, which is relates to winding up of a company. I will close this video so that you have a general idea of the Company Act. The sections that deal with winding up are in great detail, and that can be, we can discuss them in another video. But normally when you set up a company, run a company, these are the things: share capital, incorporation, name of a company, that you have to deal. Now, this section defines who is a member. Everyone who is a promoter, starter, a subscriber of the Memorandum of Association. That means that if your name is in the Memorandum of Association at the start of the company, you become a member. And then there are other ways: you get allotted shares or you get the capital. Then there is a register and index of members. And in case of listed company, public company, this becomes very important because dividend distribution and everything. And even with single member company and private limited, register of members is must. Index of member. Then trust not to be entered on register. Then a trust company or a trust cannot be entered as a member. Register of debenture holder means debt holders, your creditors who have given you money against your fixed assets or collateral, are called debt holders. Then their index, then their rights to see who can inspect. Obviously, you can inspect if you are a shareholder or a debt holder. And these are power to close register. This is for dividend distribution. Obviously, there has to be a cutoff date on which date a member, if becomes a member, then he is entitled to dividend. Otherwise, if he is not a member on that specific date, he won't get the dividend for the year. So that is the power to close the register of members. Then the court has the power to rectify the register if there is any mistake. Then punishment for fraud: if the company director, CFO make any fraud and enter fraudulently any person's name or a thing, so it can be a problem. There is section 123 which has been, and now 123A has been added. So after 123, another section has been added, and it is of much importance because according to this amendment on 26th August 2020, the amendment and 123A section has been recorded. Record of ultimate beneficial owner. So if a company shall maintain a record of ultimate beneficial owners, which means that if the existing shareholders are natural persons and they do not benefit from holding these shares, then the ultimate beneficial owner is someone else, meaning that these shareholders whose name is entered in the register of members are not our proxy members, and the ultimate beneficial owner is someone else who directly or indirectly has 25% shares and more and effectively controls the company. And so the company, this section says that a register has to be maintained of these ultimate beneficial owners along with all of the shareholders, as we saw in section 120, 121 and 120, 119, 120. ठीक है, index of members. And along with these, we also have to maintain, after 123 section, there is section 123A. We have to have a section, an index of ultimate beneficial owners, which means that if someone has been entered as a member, but he does not receive the dividends or does not control the company, he is a proxy member, then another register index has to be maintained, and the real owner has to be entered. And there are a few forms which have been recently issued according to the rules regulations, form 41, 42, 43, which have to, and for form 45 especially, has to be filled online regarding these ultimate UBO, ultimate beneficial owners. Moving from the register of members and debenture holders, this is the annual return. Every company having a share capital once in a year prepare. So this is when I was discussing section 70, that was the allotment of shares when prospective is issued. And a slight correction, the annual return form A is issued according to section 130. Every company having a paid up capital, be it a single member company or a listed company or a private company, it has to issue a form A telling what is the share capital, who was the director, what changes have been made. And then there are few exceptions for keeping in mind that if the paid up capital is less than 3 million, you have to see if you have to, if there is no change, then no need to file this form annually. But mostly, if you have a paid up capital of more than 3 million in a private limited company or a listed company or a public company, you have to fill this form to inform the SECP of all the changes in the officers, the changes in paid up capital, the changes in debenture holders, etc. Now, every public company has to have within a period of 180 days has to have a statutory meeting and discuss all of these requirements. This is for public limited company. And annual general meeting, this is for every company. Every company has to, in every calendar year, has to have a annual general meeting where they have to discuss the accounts, dividends, and all those things that affect their shareholders. If they have to have a shareholder meeting during the year, they can call an extraordinary general meeting, and the quorum, the procedure, and everything is given here, as well as in your article of association. And these are different rules regulation regarding the meetings and votes. Every member will have one vote, what will be the meeting, who will call the meeting, when will be the auditor present in the meeting, and things like that. So all of this has been given. Quorum means the total number of people, minimum number of people in every meeting, in the general meeting, that should be present to make that meeting a valid meeting. And 25% of the total voting power should be present through video link or personally or through proxies in the meetings, annual general meeting, to make it a valid meeting. Power of the court to declare, this is the power of the court to declare the meeting of the shareholders who are the actual shareholders. The court has a power of, in some cases, if there is irregularity, omission, or material defect, then the court can intervene and declare it an invalid meeting. But these meetings are the most important meetings because these are of the people who have invested their money in the capital of the business. Now, a body corporate or a corporation can also attend a meeting through its authorized representative, and federal government can also have members represented as members of a company. Now, the notice of the meeting and the resolution has to be given, and these are timelines and procedures. Voting will be by show of hands. What will the chairman declare? How can the poll be demanded on any of the topic of the meeting? poll will be through secret ballot, what will be the time of the poll, what resolutions can be passed at adjourned meetings. All of these powers and constraints are given so that minority shareholders or people who have interest in the company's creditors or are not defrauded or their rights taken away, since this is a company is not a court, and people can, directors or shareholders can, in error or intentionally or unintentionally, make mistakes which will have financial consequences for themselves as well as for other stakeholders like employees, creditors, the government. Now these are the different punishments. Then filing of the resolution passed by a company within 50 days has also to be passed with the registrar, who is the operational head, who is monitoring the company to see that if the company is following the company law. Mostly offices in SECP, in my experience of the past 15 years, is that they are very friendly and they facilitate companies in carrying out all these compliances. And also the online portal of SECP makes it helpful for any company to file those in time. Now, record of resolution and meeting, all this record a company has to keep, and that record can be inspected by future shareholders who come to become the shareholder of the company. Now, appointment and removal of director. Directors are the people who actually operate the company, and these type of persons cannot become a director. Okay, so mostly these are legal bars or some physical bars if you are a minor or unsound mind, or if you are declared insolvent, etc., or you do not hold a national tax number as per provision of it, provided they may grant exemption for requirement of this clause as may be notified. So there can be exception, but you have to have a national tax number in order to become a director. And you normally register online at IRIS on FBR portal on getting a national tax number. If you are a Pakistani, if you are a foreign national, you'll have to physically come and get your national tax number in the city where your company is incorporated. Then these are also some other exceptions. Okay? Is not a member shall not apply in case of a person. A chief executive can also not be a director. And then there are for government a whole-time director who is employee of the company, etc. Minimum number of directors: single member 1, private limited 2 directors, public limited 3 directors, listed companies 7 directors. So these are the minimum number of directors there should be. Number of directorship is no person shall after commencement hold director including alternate at the time more than such number of companies. This is a limit on how many directorships you can hold, and which means it is not unlimited. You are limited to listed holding 7 companies should be the maximum. 7, a director is not more than 7 companies. You can't be a director in more than 7 companies. This is very important. Code of corporate governance means the decisions the directors make have to be such that they benefit the shareholders, whereas as well as other stakeholders also. So the directors just can't make decisions which will benefit them and be keep the shareholder at a disadvantage. So this is code of corporate governance, and there are separate regulations and rules given by SECP which every single member company to listed company has directors of listed companies have to follow. Now, first directors and the term, the persons named in the memorandum automatically become directors. After 3 years, they retire and then they are reappointed. What is the procedure for election of directors? And when they are elected, they have to be you can also remove the directors. There can be nominal directors also, and then there is independent directors, for public companies. So all these different types of directors, and you have to also report to the registrar that who has been director in the form A we discuss in section 130. Then these are the penalties, and then there is some restriction on the remuneration of directors. Director performing for extra service including holding of office of chairman shall be determined by board and in accordance with provision of company articles. So articles will define that what will be the remuneration. Vacation of office by if a holds ceases to hold an office, what will happen? How will be the election? Disqualification by directors can be disqualified by the commission now also for doing any of these things. For example, person is involved in illegal deposit taking, which we saw according to section 80 also. You cannot take direct deposits from public as a company except when you are a banking company. Now these are the personal liability of company debts of directors, prohibition, penalty. So all of proceedings of the board, the quorum, the minimum number of directors required for the listed, for private limited, all of these are given here. For listed, it's 4 directors have to be present in the quorum. Bankrupt records, meeting, all of these have to be taken care of. You have to record them through. Then you can also circulate a resolution if all of the directors are not in the same city or in the country. Then liability of directors and officers, protection of independent and non-executive. So since this is a law and it protects and punishes different persons doing different activities like directors, shareholders, creditors, so all of this has been defined here, and the company itself can take action according to this law against their law, against their directors if they take do anything that is illegal or given in this law which is illegal. Loans to directors, members have to approve loans to directors. What is the power of the board? All of this has been defined. This is power of the board, which means that article and association, along with article and association, these are the powers that the board can exercise: invest money, undertake business, declare dividend, all of these, and some constraints have also been put on this. Political contribution, there is a prohibition on political contribution to political parties, and prohibition on giving gifts. Then these are the sections of the chief executive, who will be the first chief executive. The name, determined subscriber. Normally nowadays when you incorporate a company, you have to specifically specify a person who may not be a promoter, director, shareholder as a chief executive. But normally people who are promoters, who are starting incorporating the company, one of those shareholders, promoter, becomes the chief executive, and as a chief executive you don't have to hold any number of shares. Appointment of subsequent, once he retires after 3 years, then the terms and conditions, the restrictions, who is disqualified, how to remove the chief executive. If the chief executive is competing with your business, then what you can do. Chairman of a listed company, what is his power? Publicly listed company, bar on sole purchases, sale agents. Register of directors and officers. The register of directors and officers, there has to be a proper register, and which can be inspected by members and other persons. Then there are some other details about the different contracts that directors and chief executives can sign, and investments made in associated companies and undertaking, limit on or the procedure, how will they go forward and invest in businesses where they are also directors in those businesses, or they have financial interest in those businesses become the associated companies of this business in which they are directors, chief executives. So the rules, so that nobody gains illegally from this company. And then how will be the investment, in whose name will it be held, in the company's name, and what will be the procedure, what will be the method of contracting, execution of bills, how the directors will be, duties of the directors, in discharging all these contracts, all of this, and so that no fraud is made. And normally directors used to use their family members and show them as purchaser or sale agents or do contracts with them to benefit. But now there is a bar on all of this because the directors have to disclose related party transactions. All of this is now become law, and if directors are related to the parties from whom they are purchasing goods, services, they have to disclose so that the shareholders can know that if they are making illegal profits or unnecessary profits, or if there are other better suppliers, and just because the directors are related to these suppliers, they are making these transactions. So all of this has been put in the law to protect shareholders when the company is being run by professional directors and people who are other than shareholders, and even when they are shareholders, to protect other shareholders who are not part of the management or day-to-day management of the company, registration of contracts, etc. So as I said, that all these sections deal with the day-to-day running, and the purpose is to protect the interest of shareholders, the executive, chief executive, secretary, directors, everyone. Okay. After these sections, we'll come to the company. There are different types of company: security, deposit, employees provident fund. What is the responsibility of the money that is being kept outside the company for the employees in the shape of provident fund and gratuity and other kinds of fund? They have to be deposited in national saving, which is a government scheme, so that they are secure. And other constraints which require the directors to keep this money safe. Now, the last thing that we'll be discussing is that whenever you make a single member company, a private limited company, a public or a listed company, you have to keep the books of accounts, and there is a detailed discussion not only in these sections, but there are separate schedules, schedule 3, 4, 5, which gives you the type of reporting, the type of the format of financial statements which you have to follow if you are a small company, if you are a medium sized company, if you are a large company, if you are a listed company, if you are a company in which the government has invested. So this company law is an improvement on the previous Companies Ordinance 1984, where different reporting requirements, financial reporting requirements and audit requirements have been given for different companies, keeping in mind their structure, their size, their transaction, their turnover, their sales. So from section 220, we talk books of accounts. These are compulsory for every company to keep. Then they can be inspected by the commission as well as the shareholders. The financial statements are placed in front of the shareholders in the annual general meeting. They are approved by the directors. The directors have to sign. This is the classification I was talking about. And in the the third schedule, different classes of companies have been given, and fourth and fifth schedule defines what kind of compliances they have to do, what kind of contents of financial statements should different companies have. Obviously, small companies have limited resources, so they follow the small company rules. The listed companies, public companies, follow the international financial reporting standards. So things like that, duty of the directors, their compliance, they have to sign the reports, what should be the content of the director's report. Every company has to issue director's report and tell in details what is the financial futures and earnings of the company. Consolidated financial statements have to be made by holding companies who have subsidiary companies along with their own financial statements, financial year of holding company, rights, financial statement of Mudarba companies have been introduced. These are special Islamic companies which provide capital to skilled people, so that one person contributes his skill, the other capital, and their financial reporting has been clearly defined along with their law, which is the Mudarba Flotation and Control Ordinance 1980. They have to also follow the section of the Company Act. Now, approval and authentication, the directors have to authenticate and the shareholders have to approve the financial statements, annual financial statements. Then the copy have to be sent to registrar, who has to file unaudited financial statement. A private company not being a subsidiary having the paid up capital not exceeding 1 million rupees has to file unaudited financial statement, which means that they don't have to be audited by the auditor or the chartered accountant or the cost and management accountant. What are the rights? What are the penalties? Quarterly financial statements have to be filed by listed companies, and whether they have to be audited or unaudited, then power of commissioner for accounts, debenture holders. Now, dividends, how are dividends to be declared? Dividends are only have to be paid out of profits. Neither can the share premium amount be used to pay dividend. Dividend not to be except what to not to be paid except to registered shareholders, and this is important that only registered shareholders will get on the closing of books, as we saw in the previous section. Dividends not to be held, withhold declared dividend. All those declared dividends which have been declared cannot be withheld by the director. So unclaimed shares, all of these matters have been very clearly defined in the Companies Act 2017, so that whenever a problem arises, there has to be establishment of an investor education fund, and so all of these sections have to be followed by different companies. How will be the auditor's appointment? How will they be removed? What will be the fee? All of these matters in conjunction with the Chartered Accountants Ordinance 1961 and Cost and Management Accountants Ordinance 1964 have to be dealt, and who cannot be a auditor of the company and who can be, and when the auditors are appointment, what are their rights, what information they will be given, what are the duties of the auditors. All of this has been defined so that if an auditor doesn't fulfill his duty, he can be held to misconduct and audit of cost. Those companies like cement and other companies which need to have their cost accounts also audited along with their financial accounts. Cost audits mean audits of audit of their management accounting as well as audit of their financial accounting. Management accounting is internal accounting, but some industries have to have their in management accounts, internal accounts also audited by external bodies, signature of auditors. And so you can see that these are all the important sections till 253 which deal with the successful running of a company, and these are the sections which will help you to grow your business while keeping intact your position as a director or a shareholder, as a chief executive. You are fully legally covered in all aspects if you smartly understand your memorandum of association, your line of business, your articles of association. Then every year, if you make properly compliances on your e-services, then you will have no problem in managing your company, running your company, and the value of your company will and the goodwill of your company will improve every day. So you are watching Tax Masterclass. We had a comprehensive look at how to incorporate your company, how to use e-services to make compliances, quarterly, annual compliances, and what are the different expectations from you as a director, shareholder once you make a company, and what are the inherent powers and abilities of a company to regulate its own businesses, and what are the regulatory duties of Security Exchange Commission of Pakistan, which is the regulatory body which regulates not only regular companies but also financial, non-financial companies, Islamic companies, stock exchanges, and special companies. So if you have any question, you can leave it below in the comments. You can also contact us on WhatsApp number which is given below in this below this video. I hope that you had after watching this video, you have a clear understanding of who can be the directors, what are the requirements of the shareholders, how are the shareholders protected, who are the promoters, who are the first management and shareholders of the company, how do you incorporate a company, what are the requirements to fulfill to keep a appropriate name of your company, and how you can proceed with the day-to-day business after getting the auditor certificate and after setting up your company, and how many types of company you can have, starting from a single member company to a private limited to a public to a listed company to a public interest company. So all of these are available, and also a limited liability partnership, whose law we'll see some other time, can be incorporated in Pakistan, and that has to be registered with the SECP, Security Exchange Commission of Pakistan, rather than the registrar of firm, which only registers regular partnership business. So if you want to start a limited liability partnership, which is which is like a company as well as a partnership, you have to register it with the SECP. You are watching Tax Masterclass. I am Advocate Anthony Williams. Thank you very much. Have a nice day.